Afternoon. I'm Curt Levey, president of the Committee for Justice. Welcome to the latest in our series of weekly panels. This one's about Google v. Oracle, battle over the copyrightability of computer code. It was argued this Wednesday in the Supreme Court. My colleague Ashley Baker was going to moderate, but she's out with an emergency, so I'm going to try to be panelist and moderator. I'm sure I won't do as good a job as Ashley, who's moderated many of these, but I'll do my best. And the other two panelists who'll be joining me are Professor Adam Mossoff. He's a professor of law at the Antonin Scalia Law School. That's at George Mason University. And Terrica Carrington. She's the VP of Legal Policy and Copyright Counsel at the Copyright Alliance. She's testified before Congress on some of these issues, and after the panelists speak, we'll discuss the case amongst ourselves. So I'll give an overview of the case and why I think Oracle should win, and then Terrica will speak, and then Adam will wrap up. So look, I'm not a Google basher. I like the company, but I just think Oracle has the better legal arguments here. No matter whether you look at it from a policy or a legal point of view. Of course, I'm biased because the Committee for Justice filed an amicus brief in support of Oracle, which I co-authored. But let me start at the beginning of the story. About 15 years ago, Google set out to develop the Android operating system for its smartphones and these days other mobile devices as well. And they wanted to take advantage of the fact that app developers are very familiar with the Java SE development platform. It's come to be the standard. It's very popular. So without getting a license, Google copied about 11,000 lines of Java SE's code, as well as the organization of the code. And they could have developed their own mobile device software platform from scratch without copying. That's what Apple and Microsoft did. And as a matter of fact, at oral argument on Saturday, a few justices such as Gorsuch and Sotomayor harped on that point that, if Apple and Microsoft did it, why can't you do it? So because of the copying, Oracle, which owns Java SE, sued for copyright infringement. And Oracle won twice in the U.S. Court of Appeals for the Federal Circuit. That's the circuit with the most expertise in the nation when it comes to intellectual property. Under a straightforward, text-based analysis of the Copyright Act, I think this case is pretty simple, that Oracle should win. No one disputes that computer code has been protected by the Copyright Act, at least since 1976. So Google argues that the copied code, the declaring code, which is basically Java function declarations, you can think of it as an interface that the developers interact with, that they want to say that part of the code that they copied is not copyrightable, unlike the implementing code that implements the functionality rather than interfacing with it. And of course, it's the convenient argument for Google to make because the declaring code is what they copied and what you'd want to copy if you want it to be familiar to developers. There certainly is no such explicit exception in the Act for saying that declaring code is not copied, and the justices on Wednesday seem skeptical that there is any principal distinction between declaring and implementing code for copyright purposes. So Google's attempted distinction rests on the argument that declaring code falls under Section 102B of the Copyright Act's exclusion of procedures, methods of operation, etc. And in a colloquial sense, all code is a method of operation. But that proves too much, because if that's the reason that it's not copyrightable, then no computer code is copyrightable, and we know that's not what Congress intended. What Section 102B really is doing is codifying the long-standing principle that copyright protects an author's expression of an idea rather than the idea itself. And if Oracle were arguing that it owned the idea of a platform with the functionality found in Java SE, then 102B would apply and it wouldn't be copyrightable. But Oracle only claims a copyright in the particular declaring language that Java's creators use to express that functionality, not in the general idea of the functionality. And Oracle owns that expression, that particular expression, as much as a composer owns, the particular sequence of words and notes in a song. Similar problems with Google's other main argument when it invokes the copyright merger doctrine. That comes down to arguing that there's only one way to express an idea, so the idea and expression merge. And both that and the 102B argument really come down to saying that declaring code is too bound to its function to be expressive. There's only one way to do it. And granted, computer code isn't poetry or art, but again, it proves too much because all computer code is bound to its function, and we know it's not the case that all computer code is unprotected. So, the bottom line is there's countless different and creative ways that one could build a programming interface with the functionality of Java SE. And again, Apple and Microsoft did just that. Still Google disagrees. They say this is the only way you could have done it. And they're right, but only if you're, if you don't want to go to the trouble of developing your own interface. They're right only if, you've already made the decision to piggyback off Java's interface. If I'm developing a new search engine, I'd like to copy the exact look and feel of Google's search page. Saves me time and everyone will be familiar with it, but Google will rightfully sue me for violating their trademark. I kind of like the analogy that Oracle's attorney used at oral argument. He said, if you write a book about Seinfeld and you want writers to be familiar with the dialogue, then you have to copy a lot of the dialogue from the show. But that doesn't mean that the dialogue loses its copyright protection. In other words, you can't just say because it's popular, I have the right to copy it. Google also makes another sort of similar argument. It says that copying is necessary so that Android, the Android operating system, can be interoperable with many other systems using Java SE. Well, again, they should have licensed Java SE if they wanted that interoperability. And there's no such exception for interoperability. I'm having trouble with that word today, anywhere in the Act. So all of these args come down to, wanting to copy Java SE because it's very popular. And as Robert said at oral argument, there were a lot of ways to do it when Java was designed, and the fact that the programmers liked the way that Java's designers did it, and now, everyone uses it, seems unfair to penalize Oracle for that. So bottom line is copyright law is just not on Google's side. Google is asking the Supreme Court to change the law, and I guess that's why Google and its amici have all sorts of policy arguments that the sky will fall if Oracle wins. But again, they're policy arguments, not legal arguments. And it's been 6 years now since the Federal Circuit's first decision in Oracle's favor, and the sky hasn't fallen. It hasn't even come close to fall. Software industry has continued to do well and prosper. In any case, the court's job here is to interpret the act, not to engage in some free-ranging search for the best copyright policy. That is, unless you believe that courts should make policy, unless you believe in judicial activism. Also, finding the best copyright policy requires a balancing of complicated and countervailing factors, and it's really something ill-suited for courts to do. It's hard enough for Congress to do it, but Congress has successfully performed that balancing act repeatedly over the decades when amending the Copyright Act to keep it up to date. And so really the audience for Google's policy arguments and its problems with the current state of copyright law is across the street in Congress, where they can change the law. And I'll just conclude that saying, based on oral argument, I strongly suspect Oracle will win. With the exception of Justice Breyer, the justices seem skeptical of Google's main arguments on Wednesday, the method of operation and merger line of argument. So, but we'll see. We'll find out sometime probably either early next year or as June approaches and the Supreme Court term ends. So let me turn it over to our next panelist, Terrica.
Thanks, Curt. I think that was a great overview of the case. You touched on a lot of the really important issues in this case. So what I'm going to do with my time is, kind of talk about the implications of this case and how the issues might impact the creative community if the Supreme Court decides in favor of Google as opposed to deciding in favor of Oracle. So the first thing I want to point out is, one thing that really stands out to me about this case is that despite it being a software case, the entire copyright community is very invested. So there was very extensive briefing, and I'm talking about amici briefs in this case. There were approximately, I believe, about 60 or maybe over 60 briefs filed on both sides. And specifically on Oracle's side, you're seeing briefs from, for instance, IP professors. I know Professor Sandra A. Stars drafted a brief along with her clinic that represents the views of IP professors, but also you're seeing briefs from creators all across the spectrum. So you're seeing book publishers, record labels, authors, photographers, graphic artists, journalists, and also software companies who are all taking the time to weigh in on this case, because it's not a case that's simply limited to software. Of course, the subject matter of the case is software specific, but the implications of a potentially wrong decision would touch all areas of copyright in all industries. So, that was one of the things that first jumped out to me about this case. And I think it definitely speaks to the potential impact. The strategy that we've seen with Google here, I think, is what I would describe as pretty much throwing everything at the wall to see what sticks. And I think as a result of that, some of the arguments that they make, if successful, could potentially undermine the very foundations of copyright law. So just to add a little bit more to what Curt said about some of their arguments. So Google's lead argument is that the Java API is not copyrightable subject matter. So what they're doing here is basically arguing that the law should distinguish between implementing code and declaring code, as Curt mentioned. And by doing that, they're asking that the law recognize a distinction that is not recognized. In fact, Congress specifically rejected the idea of making this sort of distinction when they first granted copyright protection to computer programs in 1980. Notably, Congress could have chosen to carve out a specific, unique set of stipulations for how copyright law treats software, but instead it chose to treat software as a literary work. So the protections afforded to software by copyright law are no different than protections for a book, for a magazine, and also for other kinds of works that are not within that literary fold. So I think if Google were to win on this argument, specifically this copyrightability argument, this would be the Supreme Court essentially rewriting the law in a way that would strip vital protections from the software industry. And these are protections that have directly contributed to the success of the software industry. So I think if Google were able to win on this argument, it would be set a terrible precedent and have a significant negative impact on the success of the software industry going forward. But even more broadly, I think that if an infringer can successfully argue to the Supreme Court that they should essentially strip protection from an entire category of works without any basis in the law, that's not only dangerous and terrifying precedent for the landscape of copyright, but also just for the law more generally. I mean, Congress is the body that's empowered to make these laws and to take into consideration the various arguments and policy rationales for the decision that they made. So, I think that's the biggest risk with the copyrightability argument. I think, thankfully, that argument is very, very unlikely to be successful, both based on the oral arguments that took place yesterday. I think it was very clear that the justices did not find that compelling. Google also pretty much abandoned that argument pretty early on in the oral arguments. But then also, if you just look back at the procedural history of the case, copyrightability was determined, way back in 2014, and the Supreme Court actually denied cert review back then. So I find it, really hard to imagine that they would side with Google on this argument, which I think is something very important. I think that's the desired outcome there. Another argument that Google makes is that the use of the code is excused under the fair use doctrine. And this actually isn't a surprising argument, and I don't say that because I think it's a good argument. I say that because infringers constantly turn to fair use as sort of like a catch-all. I've used the work without permission, and now I'm in trouble. So how can I excuse this? What arguments can I make to try to get myself out of trouble? The number one argument that you see being made is fair use. And I think that has a lot to do with the fact that the fair use inquiry is a very highly fact-specific inquiry. So it's a little bit more squishy, less of a straightforward, bright line kind of rule situation. And also, frankly, courts and juries often get it wrong. And I think, and I mentioned juries here because that is exactly what happened in this case. So before it actually got to the Supreme Court, there was a jury that made a decision that determined that what Google did here was fair use. But if you actually look at the factual record that the jury had to go by, there's no reasonable basis as to how they could have come to such a conclusion. And to my point about just the merits of this argument, I think, again, there's nothing to support it on the record. And notably, both the first and second fair use factors, those are, the first factor is purpose and character of the use, and the fourth factor is the effect of the use on potential markets. Those are the most important of the four fair use factors, and by any reasonable interpretation, Google loses on both factors. They admitted that the purpose for which they used the code was the same purpose as Oracle's Java SE was created to be used for. Their only argument under factor one is essentially they're trying to say that their use was transformative, based on the fact that they are using it in a different platform, which is, there's absolutely no basis for that. Transformative use is, a use that changes the character and changes the purpose of the original use, and that it absolutely didn't happen, and Google also concedes that as well. But to the point of fair use, going back to the oral arguments, most of the discussion that took place about fair use was actually more so about the standard of review and less so about the actual substance. There was some discussion about the substance, but most of it was about the standard of review, basically because of the fact that a jury has already come back and said that they thought that this was fair use. So, Oracle is arguing that the Supreme Court should be reviewing this de novo because fair use is a legal question, and based on the record, there's no set of facts that could reasonably lead someone to conclude that this would be fair use. Now, of course, Google's making the exact opposite argument. They're saying that it's a factual question. The Supreme Court only should be looking as to whether the jury could reasonably have arrived at that conclusion. So, I'm not going to get too much into the standard of review because that's not, my area of expertise. But I will say that one potential implication that did arise during the oral arguments was this discussion about how if the Supreme Court rules that basically this fair use interpretation is more of a factual question than a legal question, the downstream impacts that would have on summary judgment practice and just trial practice in general. And then finally, I want to touch on the last argument, which I think is probably Google's strongest argument, but also still not a strong argument, if that makes sense. So it's their merger doctrine argument. And I say strongest argument not because I think there's actually a strong basis for it. I think as I was listening to the oral arguments yesterday, I think based on some of the questions from the judges, it was a little bit unclear which way they were kind of leaning with that. I think a lot of their questions were sort of just trying to grasp the concept and just trying to get a better understanding of it. But basically, Curt touched on this, merger doctrine says that if the expression, the copyrightable expression can only be expressed in one way that the expression merges with the underlying idea such that that expression cannot be protected by copyright. So Google is arguing here that, well, the code, there's only one way to write this code. And so because of that, it merges with the underlying idea and this code should not be protected. And I find that argument troubling for a few reasons, but the primary one is that, at the time that Oracle developed the Java SE API, there were a number of ways that the code could have been written. They chose a specific way to write the code, and fortunately for Oracle, that has become the popular way to do it, the way that most programmers, the way that most coders know of, what they're most familiar with. And so when Google makes this argument that there's only one way, what they're really saying is that this is the easiest way, this is the most known way, this is the most popular way, and to find another way would take too much work. It would cost us too much money. It would take more time than we are willing to invest. So it's not accurate to say that there's only one way to write this code. And I think we can look at the market and see that that's true. Apple didn't have to copy in order to implement their cell phone operating system. Microsoft didn't have to copy. I mean, there are other, smaller players that have created code based on Java that did not have to copy. And so I think, a part of the big implication that I see if the court were to come out wrong on this is that they would essentially be penalizing Oracle for the success of its product. And that is a direct undermining of what copyright is supposed to do. It's supposed to incentivize creation, and it's supposed to incentivize this exact kind of creation, high quality, successful creations. And so to turn around and penalize them because they did just that, would be detrimental to copyright as a whole. And just to kind of wrap up my time, I just want to make one other point, and that's, most creators cannot afford to bring, or much less sustain for 10 years, a federal copyright case. Oracle, is a very successful company. They can afford to do that, and they have done that, but most creators just can't. And so because of that, the kind of blatant infringement that we see taking place here is not really shocking or unexpected. I think it happens much more than, people commonly know. But the fact of the matter is that most creators cannot take a stand and cannot actually litigate on their own behalf. And so, I think this case is very important because I see Oracle as standing in the shoes of all creators, no matter what, industry they're from, and standing up to Google, standing up to infringers who basically try to do this kind of, I'll take now, and if you find out about it, you'll just have to sue me if you can afford to do so. That's, it's anti-competitive behavior. It's inappropriate. And I'm confident, based on the arguments yesterday, that the Supreme Court will rule in favor of Oracle.
Thank you, Terrica. That was a great presentation. Adam, would you like to wrap up?
Yeah, I'd be very happy to. Really delighted to be on this panel with Terrica and Curt, and I'm largely in agreement with their excellent summaries and assessments of the issues. It's always very dangerous to predict how the Supreme Court might rule after an oral argument, but out of the gate, it was fairly clear that the court was not really happy with Google's argument about on the copyrightability of the computer software program in this case. I mean, if you looked at all of their analogies, and the Supreme Court always works with analogies in these cases, you see them always invoking analogies. And out of the gate, Justice Thomas was comparing this to taking a team's playbook, in a sports context. Chief Justice Roberts talked about, well, how is this like cracking a safe? And you just steal the instruction manual on how to crack a safe. And ultimately Justice Gorsuch, who expressed concerns that, like as Terrica was saying, that this was very much, well, you took something because it was successful, and that's exactly why it's successful. And your arguments are it was successful. So it sounds like someone who just wants to take someone else successful competitors' facilities and say we get to use them because they're successful. And that doesn't just run against kind of IP policy, that runs against all of our understanding of exactly what we're supposed to be achieving, not just in our innovation economy more generally, but in our society, that if you produce something, you should reap the fruits of your labors in the marketplace and in your life more generally. And so it really did appear that the court wasn't really buying their copyrightability argument. Google's counsel constantly got pressed on, well, what's the limiting principle? Going back to kind of Curt's original point that, they were really concerned about this, adopting this functional argument would create an exception that swamps the rule. It's kind of what we've seen happen in patent law with the patent eligibility doctrine, with the exceptions swamping the rule recently on what counts as something being patentable. And so it's interesting to see them expressing a concern about this in the copyright space that they haven't really faced up to in the patent space. And when they do face up to it in the copyright space, that you would take note of that, because they haven't really shown a concern about these matters in the IP space in the patent law context with respect to inventions. And the fair use point, as Terrica mentioned, I think very nicely, is that, at root, what Google did here just couldn't be fair use. Fair use is using someone's words to quote them in a book review, to use in a teaching context, to use as a parody, to engage in social commentary, right? This is where the concept of transformative use evolved. Google took something from originally Sun Microsystems before it was bought by Oracle. It took a program solely for commercial purposes, commercial use. It wanted to develop a smartphone to compete with the iPhone in the burgeoning mobile device market. And it has very successfully competed. Like Curt, I am a huge user of Google services. I've used the Android phone from the very first Motorola Android phone. By the way, Google got a license from Lucasfilms to call, Motorola and Google did, to call their phone the Droid. So at least they were sensitive to IP issues in that context. But it's very interesting to note that when push came to shove, they really felt like they didn't need to take a license in this instance. And so I really think, squarely on the matter of substance, on the copyrightability issue and the fair use issue, 100% agree that the court really didn't show much receptivity to these issues, at least as a substantive matter. As I mentioned, they did show a lot of concern about the procedural questions about fair use. What's the standard of review? Is this a legal question or a fact question? They kept returning back to that issue. And so, there's some indication they might actually, remand on that issue. And so going forward, if we want to start thinking about these issues, this should be, it's understandable why they think of this as a question of law, because this involves the interpretation and application of statute, which is straightforward question of law. But there are aspects where sometimes statutory provisions do involve underlying questions of fact. We've seen this in the patent law context. And so what they might end up doing is developing something like what the court has developed in Section 103, non-obviousness doctrine in patent law, which has said, well, this is ultimately a question of law with underlying questions of fact. But at the end of the day, as a matter of course, it's treated like a question of law. And courts continually reverse with de novo review repeatedly on appeal on non-obvious issues, including the U.S. Supreme Court, which has shown zero deference to underlying fact questions and then its non-obviousness cases under this standard. So to the extent that this happens to be kicked back on this procedural issue, I think that there is a lot of ground and a lot of areas we can point to show that how this has been treated up to now should continue to be treated by the courts, just with a slightly different language in terms of the appropriate standard of review. But at the end of the day, it was really notable that all of the parties, Oracle, Google, and the US government, which argued on behalf of Oracle, all got pressed on the innovation point. They all got pressed on the innovation point that had been raised by the parties, by the US government, and by many amici, that if the other side wins, that this will be a death knell for innovation. The justices seem to be very concerned about this policy issue. And I think this is an important point, and I think it's really important that people who kind of are following the deployment of intellectual property assets in not just the creative industries, but the innovation industries as well, should pay close attention to. And we should constantly be challenging this kind of conventional wisdom, which is often expressed by Justice Breyer and many others, that it's openness without intellectual property, or locking down something, and monopolies with intellectual property, and that's kind of a conventional wisdom framing of these issues, and it's actually quite mistaken. If we wanted, if these were monopolies, we could go back to what they originally were in the 17th century. We haven't. We could go back to royal grants. We could issue prizes. We could do all sorts of things, but these are property rights. There's a reason why it's intellectual property, because it doesn't just incentivize people to create. These serve this vital bridge to cross from the lab or the computer geek working on the code at their office or the garage. The vital bridge from that to the marketplace. They provide the foundation for people to engage in innovative business models, licensing, and innovative commercial arrangements, pooling assets, pooling rights through creative rights organizations and patent pools and other types of organizations. And this is why we've seen an explosion of creativity and innovation, especially in the high-tech space in the past 20 or 30 years. By the way, this very period in which we've had very stable, reliable, and effective intellectual property protection, especially in the patent space, but also in the copyright space in many respects, that is for computer software in this case, you've had an explosion of services and resources and incredible new products and services being brought in, new market entrants coming left and right. And, we live in a world that was unimaginable even 30 or 40 years ago, even according to people who've been geeks and who've been following this very closely. So I really, it's it's very important to recognize, and Terrica mentioned this at the very end, that at the end of the day, what you have here are companies who are very large and well-financed and well-capitalized, who have the capacity to basically say, we're no longer going to play by the rules of the road anymore, or the game. We're no longer going to follow well-settled norms of respecting people's property, respecting people's fruits of their labors, respecting the creation of creators and innovators when we don't want to, when it doesn't serve our immediate interest. And we know for a very fact that that's what happened in this case. Because it would be one thing if Google had been saying to Sun Microsystems and Oracle from the get-go, we don't think this is copyrightable. We think this is fair use. We think this is bogus. We shouldn't be negotiating with you. They were saying the exact opposite. Before Oracle finally filed a lawsuit, these negotiations have been going on for a very long time. And because Oracle had offered Java through 4 different licensing programs, by the way, one of which was open source, was free, right? But Google wanted it for their own operating system. In fact, they ultimately made it proprietary, which is why they didn't even want the open source version of it. They wanted to use it for their own commercial purposes, right? And they were saying at that time that this is why they needed a license. And in fact, in 2010, an email from Google engineer Tim Lindholm to Android lead developer and founder Andy Rubin stated this, quote, "What we've actually been asked to do," and he's referring to Larry Page and Sergey Brin here, "is to investigate what technical alternatives exist to Java for Android and Chrome. We've been over a bunch of these and we think they all suck. We conclude that we need to negotiate a license for Java under the terms we need," unquote, right? Notice, there's no other way to do it. It's just that every other alternative is bad. And in fact, they admitted not just every other alternative was bad, it was their alternative was bad. Their alternative was bad. In another email that was sent much earlier in 2006, it shows you how long these negotiations were going on, right? After talks with Sun had started to break down. Again, in an email to Andy Rubin from Chris DeSalvo wrote, quote, "Where does that leave us regarding Java class libraries? Ours are half-assed at best. We need another half of an ass," unquote, right? This is not a company that's saying, this isn't copyrightable, this isn't protectable, this is the only way to do things. This is a company that's saying, we need something, we need it quickly, we need it fast because we wanted to release a new product, and anything we develop will not be as good. Ergo, now that talks have broken down and we won't accept a license, even an open source license, we're going to take it. We're going to take it because we're a multi-billion-dollar company and we can spend 10 years litigating this all the way up to the US Supreme Court, which is exactly what they've done. And which, as Terrica has mentioned, startups, individual creators, individual inventors, universities and small companies, they're not able to do that. And this is exactly the pattern that's been happening that policy wonks now call efficient infringement, and the rest of us just call piracy business models, right? And so this is the real concern here. And this is something I've been saying for years. Look, as I said, I love Google's technology, I use it. But people have often lauded Google for their earlier motto, "Do no evil." I had a very different perspective of that motto. If you have to constantly remind yourself to do no evil, you have a problem. And I think Google has long had a problem. And hopefully the US Supreme Court will call it for this exact problem. So with that, I can see the floor.
Thank you very much, Adam. Since we're missing our moderator, why don't I throw a few questions out there, and then you two can do that as well. Adam, you just went through, why Google easily could have licensed this, including licensing it for free. Why do you think they didn't do it? Was it arrogance? It wasn't money. They already had tons of money. What was going on here? Why did they, why is this case even necessary?
Yeah, it's a great question, and yeah, it's a combination of factors. I don't know if it's arrogance. It could be. Some of it is just kind of pure just expediency. There's this norm in Silicon Valley: move fast and break things. And when the iPhone came out in 2007, Google freaked because they had been trying to develop an Android system, and Google freaked along with a lot of other companies. The iPhone was a very disruptive product, and it took a lot of people by surprise. And so all of a sudden, Google went from thinking we're going to be developing a mobile device that's going to be competing against Nokia or a Microsoft phone, to now having this kind of incredible, very consumer-friendly phone that was radically reconceptualized in the way it interfaced with the end user. And so I think as I think their emails indicated at the time, they really felt like we need to do something very quick, because we're starting from over again, and we just need to get this phone out the door, which they did very quickly. I think the Android phone was released in 2008 or 2009, and given that they effectively restarted from scratch, it's very impressive how quickly they turned around the program. But they adopted this business model, or this approach, just move faster, break things. Well, we just have to do it, and and we don't want to pay because we for some reason we don't think we should pay, which is surprising from a company that makes hundreds of millions at that time and now billions of dollars. We don't want to take the open source license, because ultimately it's not going to be open source. It's going to be a proprietary version that we're going to develop for Android. So I think they just said, well, we'll just take it, and we'll see where the chips fall. This is a very common kind of story you hear in the high-tech space, especially dealing with companies in Silicon Valley. When you talk to a lot innovators, especially creators on the copyright side and innovators on the patent side, they constantly tell you these stories of how they go to these companies and say, you're using our technology, I would like you to pay me a license, and they're told to go pound sand. And in the copyright space, Google and many other companies also have engaged in a very long campaign, both lobbying campaign as well as strategic litigation campaigns to weaken intellectual property rights. And so over the past 10 years or so, fair use has massively expanded, and in the area of patent law, patent rights have massively restricted. And you see Google filing amicus briefs in the cases in support of all of this, and this is in part because it has a business model that is about sharing of information. Google doesn't create information; it doesn't create substantive material. It makes money by people being more easily to share their own information, accessing other people's material. And so, from its I think very short-sighted perspective, it views intellectual property as a blockade to its business model, which is unfortunate because it shouldn't. Just because it doesn't rely upon patents and trademarks, it relies upon trade secrets. Just because it doesn't rely on these other intellectual property rights doesn't mean that those intellectual property rights don't serve a very important function for other business models and other companies working even in the high-tech space, which do rely upon them, especially enterprise software systems and other types of works that involve the requirements of both copyright and patents to facilitate these developments and to deploy them in the marketplace.
Well, before I went to law school, I worked for a tech startup, not doing app development, doing artificial intelligence, but I got to know the industry as an engineer, and there really was an ethos of copying things that you're really not supposed to copy. But those same people are not happy when consumers copy the software that they're selling. So the idea that you know, people violate copyright laws all the time is not a very strong law, and yet that is one of the policy arguments that Google makes. You know, to say, well, people have been copying declaring code for a long time. Yeah, and people have been, you know, copying commercial software for a long time. That doesn't immunize it. Terrica, what are your thoughts on why Google did what it did?
Well, you know, you just made a good point that I wanted to speak to. You know, Google making the point that, well, others have copied before, and you know, that seemed to be fine. If that's true, you know, the great thing about copyright is like Adam pointed out, it's a property right. So the owner of the property right has the choice to allow people to copy if that's what they want to do, but they also have the right to exclude other people from copying because they also have that right. You know, so the fact that someone else has allowed, you know, people to copy their code or copy their intellectual property is not a logical argument to then say, well, we should just not have any protection because, you know, this specific person or this specific entity chose to exercise their rights in this way. I think it's great if people want to allow their code to be used as open source or, you know, copied freely. That's totally within their right to do so, but that does not mean that Google can now just go around and copy whoever's work that they want. But to your specific question as to, you know, why did Google do this? I think Adam touched on a lot of good points. You know, this isn't something that we haven't seen from Google before. We kind of see this approach to intellectual property and to their business model as being a, you know, we should be able to take what we want, and then if we're called on it, you know, we can afford to litigate and we can afford to, you know, throw all of these arguments to the wall and see if they stick. And so frankly, I think that it had a lot to do with wanting to compete with the iPhone, feeling like they were under pressure based on time, not wanting to expend the resources, and frankly, recognizing the success and popularity of Oracle's proprietary code and just wanting to free ride on that essentially. Because, I mean, yes, Google, you know, had hundreds of millions of dollars then and billions of dollars now, but, you know, no matter how much money you have, not spending money is not spending money. If you cannot spend money and get what you want, unfortunately, there are players like Google who will do that. And even when you think about even the litigation costs that have gone into them defending their actions over the last 10 years, you know, I mean, I'm not, you know, super versed in licensing, you know, prices and how much it would cost to have license on the front end, but, you know, it's just pretty confusing to think about why that would have been the better choice, you know, to take this work, pay all these attorneys' fees, pay these court costs. And I think what that leads me to think is that it's not just about the code. It's not just about the fact that they wanted to use that. I think Google also just does not respect or care about copyright. And I think they seem to have, you know, an anti-copyright campaign that they exercise in court. That's how they choose to approach copyright. So I think it has a lot to do not only with just wanting to take the easy way out, but also just their entirely anti-copyright attitude at Google.
Yeah, I mean, I'll just add in very quickly. There was a very interesting article, I think it was in the Washington Post, right before argument about the respective contributions by Google and Oracle to the various amnesty that had filed the briefs in the case, and you know, by double, you know, Google was a funder of far more of the people filing on behalf, amicus briefs on behalf of it than Oracle. And a significant portion of that funding, if you looked at the chart, they had a little chart that compared the two, was going to academics and other types of research organizations and general policy organizations, not trade associations and other things of that sort. Which reflects exactly, I think, what Terrica has just described, is that they've been engaging in a very long campaign to reframe a narrative around, well, you don't need intellectual property for innovation. And historically and economically, that's just not true.
Yeah, well, they did, Google did get a lot of amici, so certainly wasn't with their brilliant legal arguments. I think after watching oral argument, I don't think any of the justices thought Google's legal arguments were great, but they must have, some compelling policy arguments. So of their policy arguments, Adam and Terrica, which did you find most convincing? We all agree that it should be decided on the law, not policy, but if you had to pick a policy argument of Google that really, rings with you, what would it be?
Well, I'll defer to Terrica first if you'd like.
I'm actually having a little trouble on that one, so I'm going to pass it back to you, Adam, while I think on that.
I mean, their general policy arguments have been a policy argument that they've been making for a very long time, which is the sky will fall if you respect intellectual property in this context. It's been a very consistent policy argument that they've had, that respecting intellectual property crushes innovation, crushes creativity, prevents, people won't share, people won't develop, people won't create if you allow these things to be locked up, and for people to exercise this strong right of exclude and getting injunctions and shutting people down and things of this sort. And that is essentially the essence of the policy argument that has been maintained by Google and its supporting embassy. It comes out of the framing, as I mentioned, the kind of the conventional wisdom that IP is this monopoly that we pay for just to incentivize creation, and then it locks up. You have the cost of locking up and stifling of innovation and creativity after it comes out, and you just have to balance that. I think that balancing conception, which drives that type of policy argument, is really fundamentally mistaken. It's a misconception of how intellectual property functions. And if even one just takes a moment to think about the flourishing creativity and innovation that we have had in our society over the past 20 or 30 years, within the context of intellectual property protection, copyright protection for software, patent protection for software, trade secret protection for these types of things, and so on and so on. It runs counter to everything that we know to be the case. And in fact, it runs counter in this case. Oracle had 4 different licensing options, right? 4. One of them was free, as Terrica said, you could exercise your rights. I mean, this is the beauty of property rights, is it gives you the ability to decide how you want to deploy an asset or resource in the marketplace, on what terms, whether you want it to be free, whether you want to go with a Creative Commons license or not, if it's copyright context, or even if it's a regular property, if you want to invite people onto your property and run a park or something, or if you want to build a building or a house or a commercial space. I mean, this is the beauty of what these kind of platforms for innovation and creativity allow for, which is property in general, which is what economists and historians have long recognized. It's why when you see countries that have reliable and effective property rights, including intellectual property rights, you see flourishing innovation economies and creative industries, and it's not a surprise. It's a very strong correlation. It's consistently recognized by historians and economists, and I think that's the case here as well. Now, I don't know. I think the sky will necessarily fall either if you ruled against, in a particular case, then if you rule in favor of Google, but you would create more problems, and you continue to undermine. You're taking one brick out of this platform, this foundation, this pillar that supports our innovation economy, our creative economies. And as you take each brick out, this platform becomes less reliable, less effective, less secure to be the basis for incredible commercialization and new services like smartphones and tablets and 5G and new movies and the streaming services that we all benefit now through COVID-19 and so on and so on.
And just to add to some of what Adam just said, the whole innovation argument, the whole, the sky will fall, that's something that we see in this case, but we also see it kind of across the board from parties that seek to minimalize intellectual property rights, specifically copyright. The hearing that I testified in, I think it was last week, my weeks are kind of running together now, but it was actually about the Digital Millennium Copyright Act, and some of the arguments that have been raised with regard to improving that framework for creators is that, the internet will cease to exist, and we won't be able to share information, and just all these catastrophizing arguments about, how the world will end and society as we know it will not be able to continue on if we protect intellectual property rights. And, I just think, as Adam said, that there's evidence to the contrary. I mean, we see it all around us, how much these industries have flourished, and to the extent that they have struggled, it's not because of copyright protection. It's actually because of those who seek to undermine copyright protection. So, that is something that I just wanted to touch on, because I hear it over and over and over again. And I think it's really a scare tactic, because we like innovation. We like the internet. We like, the things that we have come to know and be comfortable with and that benefit our lives. And, no doubt that those things, innovation and the internet and things like that have been beneficial. But at the same time, that doesn't mean that, copyright and things that these entities want to try to argue as being anti-innovation are such. The truth is that they want to have their cake and eat it too. They want to have innovation, but they also want to be able to take from other people, and they also want to be able to undermine other people's innovations. And you just can't have it both ways. If you want to talk about innovation, we have to be talking about intellectual property rights, which are going to encourage that kind of innovation.
There are people out there who, make a somewhat plausible argument that all computer code should be open source. I had a Marxist property professor in law school who made that argument. And even if you were to buy it, that's not the decision that Congress made. Congress could have made that decision, but instead it chose to protect computer code the same way it protects literary expression. And again, this case should be decided on the law. Let me ask both of you, what stood out most to you in oral argument, or what did you find most interesting on Wednesday during oral argument?
So one thing that I don't know if interesting is the right word, but one of you touched earlier on the analogies that were coming up in this case. And, there were all kinds of, pretty weird analogies. There were some about like restaurant menus and like mixing and organizing spices and just all kinds of things that, to me, what that demonstrated was that you could see that the justices were trying to get a grasp on this set of facts and trying to understand exactly what both sides were trying to argue. But one analogy that kept coming up was this QWERTY keyboard analogy that was raised several times. And, I think that Oracle's attorney did a good job of highlighting some of the flaws with the argument, one of which being that, a keyboard, these letters and symbols that we see on the keyboard in front of us, none of that is copyrightable expression. So that's, the first problem with the argument. But one thing that I don't know that necessarily came out in the oral arguments that I thought of when I was hearing this is that I think it was Justice Breyer was making the point that, well, if someone could have had copyright protection over the QWERTY keyboard arrangement, then they would have, by default had control over all typewriters. And, that's just so false. I mean, I don't even know where to begin, but, if a keyboard arrangement was to be copyrightable, like obviously it's not, but if for argument's sake, you could copyright a keyboard arrangement, when the QWERTY keyboard arrangement was first made, there's no reason to think that that's the only way a keyboard could be arranged. I mean, we see these keys in front of us. We know the actual way the alphabet goes. So, I mean, that's an arrangement in and of itself. I mean, there's so many alternatives. And Justice Breyer kind of insinuated that, well, because of the popularity of QWERTY, because we all know and use QWERTY, if someone had been able to have rights over that they would have, by default been able to have a monopoly over typewriters. And that's just simply not true. Once again, this is another point where it seems as though the thought is, well, because it's popular, everyone should be able to just take it, or because Google, or because Oracle created or Sun created this, popular code that coders and programmers have come to know and use, that people should be able to copy. That's just simply not right. the fact that QWERTY is the keyboard arrangement that we see on our phones, on our computers, everywhere, does not suggest that now or at any point that that was the only way to arrange the keyboard. And so, yeah, I think Adam made a good point that we see these analogies coming up a lot in cases, Supreme Court cases, but I think especially in the context of a software case where, you know, the justices, you know, might not have as much experience with that. And I think also, you know, when I was first, you know, years ago, first learning about this case, you know, it seemed really overwhelming to me at the time, because I feel like there was such a narrative about like, oh, well, there's just so many like technical aspects about this. Like, it's difficult to understand and wrap your mind around the case if you're not familiar with code. Like the argument that Google makes about like declaring code versus implementing code. Like, being a person who's not with a tech background, to me, you know, I felt like, okay, wow, am I just, you know, in over my head here? Is it because I'm not understanding the technical aspects of it? And I think really that's not the case at all. It almost seems like, you know, they throw around these complex ideas in order to sort of murky up the very straightforward legal arguments. I mean, to me, it's a really straightforward case, and you know, that's kind of what I picked up on from those analogies.
We only have a few minutes left, so let me ask you if you have any questions you'd like to throw out to your fellow panelists. If not, I certainly have another question.
Well, go right ahead. I don't have anything. So.
I can pick up on what and just what on the point of what was interesting about the oral argument as well, because I agree with a lot of what Terrica just said as well. But there were a couple other interesting things about it. Either way.
Go ahead, Adam. I want to hear you.
Well, I agree 100% with Terrica. In fact, I was someone, I'm a tech geek, and I was actually, when I first learned about this case, I originally was caught up in the narrative that had been created that, oh, this is about protecting functionality and copyright. And I said, well, you can't do that. So my initial response to this case was Google was right and Oracle was wrong. And a couple of people said to me, you should really go read the case and read the facts and, you know, the briefs and get a sense of what's going on in this case. And I did, and I realized it's not about functionality, because I originally thought, oh, this is Borland v. Lotus, you know, take two, and I agreed with that decision that you can't use copyright to protect functionalities in computer context. But I, you know, what Terrica mentioned is really right. Is you see the justices, you know, using these analogies and metaphors a lot in intellectual property. I think they're using them to try to get at the confusions and complexities, unnecessary confusions and complexities created by the narrative the narratives that are being pushed. But was, you know, a couple things that were really surprising. There were two things that were really surprising to me from the oral argument, which was one is when Justice Kagan explicitly said to Google's lawyer, "I'm surprised and confused by your argument." If you ever have a justice saying that to you as a Supreme Court litigator, right, that's not a good sign, right? When you have a justice who are very smart people say, "I'm surprised, confused," and then to have Justice Gorsuch immediately say, "I agree with Justice Kagan," right? Which, by the way, you don't normally hear Justice Gorsuch saying, "I agree with Justice Kagan." So again, this is why I think that these are the indications in the oral argument that I think that, you know, I think it really speaks very, very well of Oracle's lawyers that they were able to cut through a lot of this narrative that had been created and basically present the basic issues, the legal and policy issues, I think, that needed to be presented to the court for them to understand it. And then the last thing that was very interesting to me was when Justice Gorsuch ran his comparison to, well, this just sounds like there's a successful competitor who's really successful, and so you're just claiming I get to use their facilities because they're really successful, and so I should have access to that. And when he asked that question and made that comparison, well, isn't that what you're just arguing? I pricked up because. And Google could not have been happy with that question, right? Because that raises all of these current antitrust issues. In fact, he explicitly invoked essential facilities doctrine from antitrust, which is currently one of the arguments being used against Google from the antitrust side right now, right? And so I think there was a little bit of an implicit message from Gorsuch, right, about Google trying to have its cake and eat it too, right? Where, hey, you're arguing on the antitrust side, we're not an essential facility. People shouldn't have access to our search algorithm. You shouldn't be using antitrust against us. Oh, but if someone else has an essential facility and is successful, we should get access to them. Right. And I think there was a little bit of an implicit signaling going on there that like, hey, you're trying to have your cake and eat it too here, Google, and that doesn't fly. And in fact, that's a message I often say to my students. If you're making an argument that where it comes across to a judge that you're trying to have your cake and eat it too, you're going to lose. And these are the reasons why I think, I think a lot of us came away from the oral argument thinking that Oracle had the stronger position, although on the procedural issues about fair use, they may still remand.
Curt, we can't hear you.
You're on, you're muted. Curt, you're muted. Curt, you're muted.
Hey, Curt.
Curt, we can't hear you. He's not looking at us. I think he's reading.
Oh, I think I hear him now.
Okay.
In any case, we've run out of time, so let me thank Terrica and Adam for great presentations and for making this a very informative panel. Since COVID hit, we've been doing these panels once a week, sometimes on nerdy stuff like this, sometimes on things like Supreme Court nominations. So I hope you'll tune in again soon for another one of them. And again, thanks so much to my fellow panelists. Take care now.
Thanks, Curt. Thanks, Adam. This was great.
Yes, and Terrica, awesome job, everyone. Great. Thank you.
Bye-bye.
Bye-bye.